Good morning, everyone. My name is Pedagogy, and I am the Arthur Watts Senior Research Fellow in Public International Law at the British Institute of International and Comparative Law, as well as the Director of Teaching and Training. It is my pleasure to welcome you all for this first webinar in our series on teaching international law, which we are convening together with Dr. Barry Saunder from the University of Leiden. The webinar series today that we're launching today is the result of a quite long process of discussion between the different conveners, the organizing committee, and others. And it builds on the engagement with training and capacity building that Beckett has been undertaking over the past years, and that we've engaged with in more actively over the past 12 or 24 months. So we've been doing this training, we've been doing this capacity building, but we also wanted to take the opportunity to discuss with others who are involved in teaching international law what they see as the key issues in teaching international law, what are the key developments in teaching international law. And that is where this series comes in. Barry had a question on this some time ago that started this discussion, and I'm very pleased that we're here today to start this webinar series that has been in the works for a while. Barry?
Yeah, thanks, Jean-Pierre. I'd also like to welcome everyone. My name is Barry Saunder. I'm an assistant professor at Leiden University. And I'd just like to briefly introduce some of the aims that we have for this webinar series. Now, every project has a personal dimension. And one of my personal motivations for becoming an academic was to teach. And yet, there seems to be a surprising lack of research on teaching international law. And this, despite the fact that teaching is a practice that academics certainly conduct for a significant amount of their time. So one of the first aims that we have for this webinar is really to fill and address a gap in the research in the field that we've identified. Now, that said, the tide is certainly turning. Even over the last 12 months, there have been some incredibly rich contributions on teaching international law. And I'd just like to spotlight two, which are particularly interesting. So there was a critical international legal pedagogy symposium co-edited by Professors Mohsen Al-Attar and Rahini Sen on Opinia Juris, which examined whether a critical pedagogical disposition could be maintained when teaching international law in virtual spaces. And then there was also a symposium on teaching and researching international law jointly hosted by Afronomics Law and NUS Center for International Law, which included reflections on how to collectively reassess the international law canon currently centered on the experience of the global north. Now, these are the types of interventions that we hope this webinar will very much continue the conversation with respect to, and that's really our first aim. Our second aim is what I'm calling global reach. Our aim is to engage participants and audience from around the world. And to this end, for example, we have some exciting webinars on teaching international law in Asia and teaching international law in the Arab world. Our third aim is to engage diverse contexts, to examine a diversity of practices in a diversity of settings related to the teaching of international law. Now, by this, what we mean is that we're not just looking at the university setting, but also practitioner environments, for example. So we have, just to take one example from the series, we have a fascinating webinar in the series, which will be hosted by the International Committee of the Red Cross. And our final aim is really to inspire conversation. The webinar itself, the webinar series, is inevitably selective. Many gaps remain, and there is significant room for future research and projects in this space. And so our final aim is to inspire future conversations and initiatives on the teaching of international law. Right, with that said, I'll hand back to Jean-Pierre, who will tell you a bit more about the series itself.
Thanks very much, Barry. So yeah, just to talk a bit more about the series. So in terms of the structure, we have a series of 10 webinars, which will be held over 5 days, over a 4-month period, approximately 3 weeks apart. We've gone for Fridays because we thought that's a day that many people will not have teaching and will be able to join us for this time. And we've done 2 webinars on each day without lunch break in between, at least in the UK and European time zone. If you register to the list, you'll receive reminders for each of the days in the run up to each over the next 4 months until April. The second thing I wanted to talk about is the selection process. So we have over 50 speakers who will be participating over the course of these 4 months, over the course of these 10 webinars. But this is a selection from a much larger number of proposals that we received. Each proposal was assessed by Barry and myself, but also by 2 peer reviewers from the organizing committee. And the selection was made on the basis of the assessment that was made of those proposals by the organizing committee. Obviously, this is never going to be a perfect system, and I'm sure there would have been other excellent speakers and other excellent presentations that might not be included in this context. And as Barry said, this is only the start of a conversation, and we hope that there will be more and more of this to come. We've also been able to take advantage or to take the opportunity of current circumstances to bring more people from more places together. And I think this is one of the key strengths of this webinar series. As we mentioned, this is the start of a conversation or the continuation of conversation. And even through the webinar series, we've thought of another 2 ways to continue that conversation. So the first is that each session is going to be recorded. So if someone is unable to attend, they can at least watch the presentations in the following weeks. So this will be uploaded onto the Beckett website as we go. And the other thing is that we plan on putting together an edited volume that builds on the presentations in the series. And this will be put together over the next year or year and a half or so. The idea is that this is the continuation of a road, not an end in itself. And we're cognizant of the excellent work that has been done, not least in the informal conversations between different teachers on the sidelines of face-to-face conferences, more than online conferences, as well as recent symposia on teaching international law. So we have a few logistical points and a few notes of thanks. So I think I'll hand over to Barry for the notes of thanks before I turn to logistics.
Yeah, just a few thank yous. We'd like to thank obviously Bickle and their events team, including Liam, Bradley, and Carmel for both marketing assistance and support in setting up the symposium. We'd like to thank our organizing committee who provided incredible support, not only in peer reviewing many of the submissions that were contributed to this webinar series, but also for their general advice, support, and feedback along the way. We'd like to thank all the people who submitted abstracts to the webinar series. We had an incredibly high number, and it was a real shame that we weren't able to host everyone. We'd like to thank, obviously, our panelists, both today and the future panelists for the series, and the chairs who are drawn from our organizing committee for taking the time to chair the panels. So thank you, everyone. And obviously everyone who is in attendance, thank you very much for taking the time to attend this webinar series. It's very much appreciated.
Okay, so in terms of logistics, just a couple of things. I mean, no one here is new to this. There is a Q&A function. So if you have questions that you would like to pose to the participants, please do so as we go. It would be good for us to know what questions are coming in. So please do feel free to put questions into the Q&A box and avoid putting things into the chat function as you go. If you like a particular question that someone else has asked, please do upvote it. There is this possibility. This will put the question towards the top and will make sure that it gets asked to our panelists towards the end of the session. We might not have time to discuss all of the questions received, but rest assured that they will be shared with the panelists. And I'm sure that if there's a particular question, this can be continued offline after the event as well. But we hope to take as many of the questions received as possible over the course of the webinar itself. And if someone has a particularly convoluted question that they would prefer to ask orally, please do let us know and we can try to make arrangements for that. The other logistical thing I wanted to mention is that you are encouraged to tweet as we go through the webinars and to use the @Bickle and #TeachingIL handles on Twitter. With that in mind, thank you very much for bearing with us through all of that. It's my great pleasure to welcome this morning's chair. So that's Jason Rudel, who's assistant professor at Leiden University in public international law. He's also been a visiting professor in international law at the Université Catholique de Lille. He works in various fields of public international law, human rights, international environmental law, investment law, as well as legal theory. And in addition to his academic activities, he's worked with international organizations, NGOs, as well as law firms, as well as being involved in several investor-state arbitration cases. Jason, over to you.
Thank you very much, Jean-Pierre. Thank you, Barry. And I'd also like to welcome everybody, all the attendees, to this first panel of the Teaching International Law webinar series. This panel is entitled Central Issues from the Periphery, and we have 4 excellent contributions today. We have Dunia Zongwei, Jason Beckett, Ling Chang, and Vera Honoskova, who I'll introduce more fully in a moment or two. Each of our panelists will give their take on teaching international law from the perspective of their particular specialization or region. And in this panel, we're going to cover a wide range of such perspectives, from public international law, international human rights law, and migration law, to international economic law and climate change law. So there's much ground to traverse, and many of our panelists will also share their experience teaching in the geographical region that they are currently located in. As far as the format and structure of the panel today is concerned, our panelists each have 15 minutes to make their presentations, and then there will be 30 minutes at the end for Q&A and discussion. Please feel free to put your questions in the Q&A box as we go, so that we have them lined up and ready to go for the Q&A session at the end. So without further ado, I'd like to turn to our first panelist, who is Dunia Zongwei. Dunia is Associate Professor at the Department of Legal Studies in Walter Sisulu University. And his presentation is entitled Teachers of International Economic Law in Africa Must Beat Their Own Drums. So with that, Dunia, we very much look forward to your presentation. Thank you very much. You have the floor.
Can you all hear me? Okay, so I'll be sharing my screen. Please let me know when you can see it. Perfect. So just a second. Thank you very much for attending this webinar and my presentation. As you can see on the slide, my name is Dunia Prince Zongwei, and as Professor Rudol has said, I teach in the Department of Legal Studies at Walter Sisulu University in South Africa. The title of my presentation, again, Teachers of International Economic Law in Africa Must Beat Their Own Drums. This paper is about the theoretical necessity to publish knowledge that is relevant, to publish knowledge that reflects local perspectives. In 2016, when I was still lecturing at the University of Namibia, I was allocated the module International Economic Law. And part of my teaching duties involved coming up with a list of prescribed and recommended books. In order to do this job effectively, I felt like I had to go to the library, to the university library, and see what books we could find in the library, so that if I prescribe or recommend the text, the students will be able to get it in the library or in the electronic resources that the university had. I ended up, I found 4 texts, which you can see on the slides. And the one that I prescribed, the main text was Lowenfeld's International Economic Law. And then recommended Ray August International Business Law and Hard Against Principles of International Economic Law. The idea was that I would supplement this text with my own materials. I have to say that these 4 texts are of very high caliber, but I was nonetheless uncomfortable. I was uncomfortable because this situation, or the books that I found in the library, gave me some headaches. They pose a number of problems: a problem of relevance, a problem of coloniality of knowledge, a problem of methodology, the way information was presented in those texts, which, as I said, are nevertheless of very high caliber. But I would say that, in short, the greatest headache was the fact that in the library, I could not find any reference book in the field of international economic law that primarily focused on Africa. So now the question is, how do you get teachers of international economic law in Africa to write their own books or to beat their own drums, as I put it myself? In other words, the question is, how can law faculties in Africa overcome the coloniality of knowledge through the creation and publication of more relevant and useful knowledge? To answer this question, I've divided this presentation in 3 parts. In the first part, I will actually look at the question of the relevance of international economic law. Secondly, I'll look at the coloniality of international economic law and how that could be, in the last part, I'll look at how international economic law could be decolonized with local theories. Starting with the relevance of international economic law, in the slide you can see the building on top is the Southern African Customs Union. It's a very important institution in Southern Africa, but in the text that I've mentioned, it is not discussed. On the contrary, there's in the text that I've mentioned, there's a lot of discussions about the WTO law, etc. But this is a problem, and it is a problem because the Southern African Customs Union, SACU, which is, by the way, the oldest customs union in the world, the oldest functioning customs union, SACU matters more to the law students in Namibia and in Southern Africa than the WTO. And the reason why I'm saying this is because SACU represents the greatest source of income of 3 members of the 5 members of that union. It is the greatest source of income for Namibia, about 40% of government revenue. It is also the greatest source of income for Lesotho and Swaziland, and it represents more than half of government revenue. And yet, in the textbooks that I found in the library, I couldn't actually get lots of materials on the law of Customs Union or Southern African Customs Union, I mean SACU more specifically. So I felt that it created a danger that my students may be poorly prepared for the market and for the development needs of their respective countries. Simply put, the books that I had recommended and the standard references on international economic law. And as I said, the books that I had recommended are the ones that I had found available in the library. These books and references proved irrelevant. In short, that's what it means. But some of you may say, no, but SACU, I do not have to oppose SACU to WTO because WTO does provide for free trade areas and customs unions. In other words, you could say that by explaining or discussing free trade, most of the standard references discuss free trade, I could simply incorporate information on SACU. In other words, I can synthesize SACU or create a synthesis between SACU and the WTO. Unfortunately, I hope it was that simple. That synthesis itself is problematic because of the coloniality of knowledge that I will explain in a bit just now what I mean by that, by the coloniality of international economic law. Coloniality in international economic law manifests through 3 phenomena: Eurocentrism, 1, 2, It is doctrinalism, and then 3, neoliberalism. I don't think I'll have to define Eurocentrism, but if you have questions about it and how it affects international economic law, I'll be able to deal with that in the Q&A session. And here I'll just discuss it through doctrinalism and neoliberalism. Doctrinalism, what I call doctrinalism, consists in essence in constructing arguments from authoritative formal sources. These sources include international treaties, the decision of international courts or tribunals, a country's constitutions, or the writings of established academic authors. In other words, is what is commonly known as black letter law. Doctrinalism, unfortunately, firmly imprints itself on the main methodology used in international economic law. This is a problem because there's been a lot of research showing that the most practical way of teaching law in the African context would have to include a number of perspectives in terms of methodology. Among those methodologies, it's important to incorporate insight from development studies and economics, especially when teaching international economic law or regional trade. Development studies have the advantage of broadening the range of policy possibilities as well as solutions. They also assist teachers in empowering students to evaluate and reform existing laws. And more importantly, they empower students. I mean, they assist teachers in empowering students to come up with alternative rules. Coloniality, as I said, is not just, coloniality in IEL is not just through Eurocentrism and doctrinalism, it's also through neoliberal economic theory. Neoliberal economic theory underpins most of international economics, macroeconomics, and most of international economic law. Unfortunately, in the textbook that I've mentioned, and in the main textbooks on international economics or macroeconomics, the ideological foundations of economics are not discussed, and that is a problem. If teachers are not able to guide students in challenging the economics underlying international economic law, they will not be able to guide students in challenging them, challenging the rules that flow from international economic law. The neoliberal or neoliberalism carries disturbing implications for the teaching of international economic law in developing countries and in Southern Africa in particular, because leading scholars like Owen Feld, highly capable, unfortunately, they often assume that neoliberalism can help developing countries. Unfortunately, this sort of tunnel visioned economics, and here I'm referring to neoliberalism, have wreaked havoc in developing countries. So how can we decolonize international economic law with local theories and local stories? This is what I'll deal with now, and it will also conclude my presentation. Many students in the developing world, but in Southern Africa in particular, experience education as an alienating experience. This is because coloniality entails teaching students with texts and theories that deny their own history, their own lived experiences, and their own dreams. In other words, these text theories and curricula distort student self-image. As a consequence, African students feel estranged, they fail to relate to those texts, and they learn to hate themselves. So to avoid sounding like the authors in the main titles, IEL teachers will have to write their own books. They'll have to write their own ideas on IEL itself, on how to further decolonize the curriculum, and on whether they should fit it with wider development angles. The main titles, this is also one of the shortcomings, the main titles tend to emphasize market access and less development. You just look at one of the texts and you're not likely to see a lot of discussions about development theories and how that impacts international economic law and international economic practice. Instead, specifically, they do not offer practical ways for poor nations to survive and escape the poverty trap. If teachers of international economic law want to answer the clarion calls to decolonize their curriculum in Africa, they will have to publish, and they have to beat their own drum, to beat their own drums. That entails 4 types of intervention: theoretical. They will have to publish texts that challenge the neoliberal ideology behind international economic law. In other words, texts that propound decoloniality, the developmental state, and other critical approaches to international law. The intervention will also have to be methodological, in the sense that they will have to write texts that subvert the doctrinalism or positivism that spreads through international economic law. Thirdly, the interventions will have to be financial, and this is very important. If you look at the current statistics about spending on research and development, academic funding as a percentage of the gross domestic product, as a percentage of the GDP, you realize that most African countries, the overwhelming majority of African countries, do not even appear in the listing, in the rankings, because the funding is negligible. So it's one thing to say we have to decolonize what the curricula and international economic law, but it's another to fund it. It seems like at this point, there's a lot of talk about decolonization, but there's not enough investment in the decolonization of the legal curriculum and international economic law. And then the intervention will also have to be institutional. Both governments and universities must become involved in the decolonization project and ensure that the curriculum reflects those priorities. This may seem obvious, but in my own experience, again, here I'm referring to my experience in Namibia, what you would see is that international economic law is taught as a introductory module, but it is in a module that is pitched at the level of honors degree. So the problem here is that the content, that the aim is to introduce, to provide basic content or basic introduction to international economic law, but the module itself is actually taught in the 3rd year of the 4th year LLB degree program at the university. So this issue is not theoretical, it's not methodological, it's not about the finance, but it's about the rationality of how the international economic law is structured. But I believe, in conclusion, that if governments and universities can, and law teachers, of course, can actually engage in these 4 types of interventions, I'm confident that the libraries will not be drowned out by the tunes of research conducted in other contexts. Thank you very much.
Thank you very much, Dunia, for that really insightful presentation. We now turn to Jason Beckett, who is Assistant Professor at the Department of Law in the American University in Cairo. His presentation is entitled Harry Potter and the Gluttonous Machine, Reflections on Teaching International Human Rights Law and Public International Law in a Developing State. So without further ado, I give the floor to you, Jason.
Okay, now can you hear me? Perfect. So first of all, thanks to everyone that put this series together, and thanks for inviting me to speak. I'm in a slightly awkward situation that I have to follow up such a well-structured presentation with my own random thoughts. Jason, I don't actually have a watch with me, so can you shout at me when I have 5 minutes to go? because I have a tendency to ramble.
I will do so. Thanks.
Thank you. So first, if I may, I want to say a couple of things about Dunia's presentation, which I really liked. But I read things in a slightly different way. So first of all, I agree that international economic law is a neo-colonial project. But I'm not sure that international economic law should be reduced to the World Trade Organization. What I've been looking at in my own research recently is a thing that I'm calling the global legal order, or in this paper, I will refer to it as the gluttonous machine. And that is a combination of the World Trade Organization, the World Bank, the IMF, and the structures of international investment arbitration. And my belief is that they function together as a fully operative legal system that we have to spend a lot more time talking about. In relation to that, I'm also going to suggest that the development project is actually working perfectly, that the development project is doing exactly what it was intended to do, which is to continue to finance the overdevelopment of the developed world by continuing to plunder the resources and the labor of the underdeveloped world. My fundamental argument is that that's what international law has always been for. International law was designed as a machine of plunder, but overlain with a set of narratives of progress. So let me give you 3 figures before I start my talk proper. Figure 1, 5.5 trillion US dollars. That's 5.5, then 11 zeros. That is the amount of money, labor, and resources that flows net from the underdeveloped to the overdeveloped world every single year. Figure 2 is 345 to 1. In 1960, at the end of formal colonialism, the income gap per capita between the richest country in the world and the poorest country in the world was 30 to 1. In 2019, after 59 years of development, the income gap between the richest country in the world and the poorest country in the world was 345 to 1. Figure 3, 70% of the world's population live on less than $5 a day after purchasing power parity is taken into account. If you average out purchasing power parity to be about 3 to 1, which is a very conservative average, then that means that 70% of the global population actually live on $1.65 a day each. I say live. Exist might be a better word. Die might be a better word. Our current international economic order kills 50,000 people every single day. And international law does nothing about this. And this seems to me deeply problematic. But who is me? Who am I to talk about any of this? So I would like you to bear in mind that my situationality is very strange. I'm a white European male. I allegedly teach in the periphery, as I teach in Egypt, but I actually teach in a highly colonial space, the American University in Cairo, which is in its own way part of the continuing civilizing mission where nice, well-educated white chaps like myself can come out and teach brown people how to think better about themselves. What I have tried to do in my own work is to subvert that space, to take that space and to use it precisely to teach from a twale perspective. So I called this paper Harry Potter and the Gluttonous Machine. And I would like to say, first of all, one of my very few hipster moments is that I hated J.K. Rowling long before it became fashionable to hate J.K. Rowling. I don't particularly hate her because she's a neoliberal, because she's a transphobe, because she's a Zionist. I hate her because she's a bloody awful author who wrote god-awful books. And when I first came to Egypt about 9 years ago, Harry Potter was still like the big cultural phenomenon. All of my students loved Harry Potter. I don't love Harry Potter. I think that Harry Potter is badly written, childish fantasy that is inexplicably popular around the world. But in that sense, it's useful because international human rights law is also badly written, childish fantasy, which is inexplicably popular around the world. So one of the questions that I am frequently confronted with, particularly in my early classes every semester, is what rights do I have? I teach a course called Introduction to International Human Rights. And so this is a fair question. What rights do I have? The problem is that I can't answer this question. I literally have no idea what human rights I have, let alone what human rights other people have. And more importantly, I don't know what it means to have a human right. And I don't know why people care about or want human rights. So it seems to me, and here I'm probably heavily following Marty Koskiniemi, that human rights and international law are languages. They are media in which we can express our approval or disapproval of geopolitical events, but they're not mechanisms for altering those geopolitical events. In other words, international law is either everything or nothing. And actually, both of those things are the same. So I tragically started my career trying to understand the sources doctrine of international law. And what I slowly discovered over the years is that the sources doctrine of international law is an absolute nonsense. So it starts from the idea that there are these things called international legal obligations. But it never really tells us what it means to have an international legal obligation. It tells us that there are things called treaties, but it doesn't tell us why a treaty is different to a newspaper report, an academic article, or a Harry Potter novel. It doesn't tell us what makes treaties law. And I think the reason for that is very simple, which is that treaties are not law. But if we bracket that big claim and just think about the rules for interpreting treaties as we get them from the Vienna Convention, we get two basic rules. Rule 1 says, if you want to know what the treaty means, just read the bloody treaty. Don't add any words, don't take out any words, just use this thing called natural meaning. But Rule 2 says that if the results of Rule 1 are absurd, then instead you can look for the purpose of the treaty, and that allows you to reread the treaty, adding or removing words as you see fit. So rule 1, don't add or remove words. Rule 2, feel free to add or remove words, equals rule 3, the treaty means whatever you want it to mean. Customary international law is much, much worse. In customary international law, not only do we have interpretative problems, but we also have ontological problems. We don't know what opinio juris is. We don't know what state practice is. We don't know what the relationship between the two are. The net result of all of this is that international law is radically indeterminate. And what that means is that you can have any international rule that you want. There is a methodological or theoretical way to invent or disinvent any rule of international law. The most fabulously ridiculous example of this is the Human Rights Committee's 2018 general comment, their allegedly authoritative interpretation of the right to life, which comes down to a completely bizarre and largely contradictory wish list of things that people on the committee would like to be laws. And yet this is presented as being somehow authoritative. What I'm arguing is that it's not authoritative, that no one should care what the Human Rights Committee says. And in fact, the Human Rights Committee shouldn't exist. That money could be much better spent elsewhere. And the reason that none of this matters is that that other international law, the global legal order, the gluttonous machine, that international law is real. And it's real in the sense that it is enforced against governments, especially governments of the underdeveloped states, who don't want to comply. And as Dunia said, that system is based on a neoliberal logic. And the effect of that neoliberal logic, as Dunia also hinted, was to wreak economic havoc around the underdeveloped world. And this leaves us with an interesting problem. The global legal order defines legality as obeying the dictates of neoliberalism. But in order to obey the dictates of neoliberalism, you have to impoverish your population and govern them oppressively. As Sonaraja argues, neoliberalism can only truly work in a dictatorship. And what that means is that in order to obey the authoritative, the necessary, the enforced demands of economic law, states have to mistreat their own citizens in order to maintain order. And so Harry Potter, that thing that we call international law, then criticizes those governments for breaching its imaginary laws while never looking at the very real laws of the global legal order. I'm going to close on that point and just summarize it in this way. I don't care how people teach international law, because international law is meaningless and pointless. I do care how people interact with the global legal order, because the global legal order, behind the delusions of international law, actually regulates the world and actually reduces 70% of the global population to immiserated starvation. And until we deal with that, everything that we say about international law is as bad and as pointless as everything that J.K. Rowling has ever said about Quidditch. Thank you.
Thank you very much, Jason. That was an insightful and thought-provoking and might I say, somewhat provoking presentation. And I can see that there are questions coming into the Q&A box. Please continue to pose your questions there, and we'll come to them at the end. I'm sure it's going to be a fascinating discussion. So now we turn to Ling Chang, who is a doctoral candidate at the Faculty of Law of McGill University. And Ling has a presentation entitled Climate Law's International Preference and its Implication for Teaching and Learning. So Ling, you have the floor. Thank you very much.
Thank you so much for having me today. I will share my screen. Since I'm still a student, so I will talk more from a perspective of learning climate law, and also some experience from my past learning experience, and also like something from my reading. Like the topic today, we'll look at legal education on climate change in the context that climate law is arguably evolving as a specialized field for legal research and practice. So while there are law school already introducing standalone courses or climate law components in conventional courses, the majority have not done so in any systematic way. So for example, in Canada, so we have 24 law schools, but between 2018 and until this year, only 6 schools offer like climate law, or the title include climate law. So it's just like 1/4 of all the law schools in Canada. My paper argued that law school must join the fight against climate change by educating future climate lawyers and scholars and producing climate-related legal knowledge. This is an argument I made in a magazine article last year. If you are interested, I have put a link on the slide. I tried to make a strong case for the connection between the emergence of a legal field and the potential development in programs of legal education, tracing out the normative and institutional development in climate law and its associated scholarship and practice help both conceive of climate law as a distinctive field and posit its relative autonomy from other laws and disciplines. Their interactions that entail tensions, synergies, and hierarchies present specific challenges for academics and lawyers working in this area. It then begs a set of legal education and curricular questions like what would constitute a climate law education? What levels of programs are productive for teaching and learning, and what methods are available and effective, and how to develop interdisciplinary and even transdisciplinary courses. To answer these questions, I studied how law school in Canada and beyond have engaged with climate change and the diverse pathways through which the climate law was introduced, and in light of the select courses and their teaching substance and methods. My following presentation will highlight some of my findings. So first, while highlighting the unique features of climate law, I do not try to define climate law or make a new argument on whether and how it has become a new legal field. Instead, I identified some key perspectives on the futures of climate law and how it related to a distance itself from other legal fields, which actually serve as a stepping stone for inquiry into why and how legal education programs can and should evolve in a changing climate and legal context. In response to the collective nature of climate tragedies that transcend every jurisdiction, there arises a demand for building and sustaining a universalist agreement. That's why the UN climate regime has accordingly evolved in the past 3 decades. which is also driving climate law developments at the national, subnational, and transnational levels. To give this development theoretical frames, scholars have come up with some terms such as a transnational regime complex, polycentricity, multi-level governance, or bottom-up policy process. Reviewing the significance and implication of these governance terms is beyond the scope of my research. The intention here is to show the enormity and diversity of interest and efforts that try to account for the plurality of actors and the variety of normative activities and framework in global climate governance. So I take transnational climate law as an example. It's a broader concept compared to international climate law and comprises all climate-related legal norms that have horizontal effect across borders, such as climate regulation adopted by national governments or standards by private actors. Research has shown that this transnational approach, departing from state-driven legal process, can significantly engage non-state actors and recognize the legal relevance and contributions of soft law. As climate change is governed at multiple levels, their synergies and conflicts complicate our understanding of the overall impact of legal norms relating to climate change. Explaining and communicating the various modes of legality and the diverse lawmaking practice in climate law have brought more theoretical and methodological challenges to both teachers and students working in this area than the traditional legal fields. The complexity of climate change is unveiled in its wide-ranging impact on ecosystems and socio-economic orders. Some scholars describe climate change as legally disruptive, causing problems and disputes that cannot be easily addressed by conventional legal doctrines and institutions. Although many scholars recognize that though law must adapt to climate change in radical ways, it's not agreed upon whether those adaptations coalesce into a coherent, discrete field or evolve incrementally across different legal fields. There are discussions more focused on whether international climate law is a distinctive field. For example, there are two books published in the past few years. The first one, Mayer described his book as perhaps the first comprehensive account of the international law on climate change as a discipline. By contrast, while naming their book International Climate Change Law, Bodansky, Brunei, and Rajmani emphasized that neither is international climate law a self-contained regime, not a discrete body of laws with its own sources, methods of lawmaking, and principles. Instead, it fits better into international environmental law and more broadly, public international law. Regardless of their positions or preference, both books have located international climate law within the broader international law, including the principles and rules of general international law and the relevant developments of other international legal regimes. All this add up to the possibility for climate lawyers to be what some scholars call legal interdisciplinarians. In addition to the internal features and cohesion of climate law and its relations with other laws, there are pragmatic considerations for climate law to look for a place on the legal curricula. The incentives for seeking recognition could be promoting climate law's efficiency and other strengths by creating a focal point for communicating expertise or orienting policy and legal development in a more coherent manner. Recognition could also make a powerful political statement and lend legitimacy to a social movement such as environmentalism in the 1970s and the most recent youth student-led climate march around the world. As you can see in the picture I put here, it's a McGill law voted to strike for climate march in 2019. Specializing climate law may have other direct economic benefits, for example, getting support from funding agencies, creating job prosperities, or sending students a message that climate law is a legitimate and credible area for legal practice. That being said, what to teach at law school is informed by a sum of interests and decisions. Law schools are not the only stakeholders in legal education. As government actors, professional bodies, and civil society organizations may influence curricular subjects, skill set, and the balance of academic and practice-based training. Law schools are accordingly pulling the different directions given these internal and external actors who define and redefine the content and format of legal education. Now I will turn to the responsibility of law school to teach climate law. Law schools have occupied a central role in producing and reproducing knowledge, fostering expertise, and governing elites. They must take on the responsibility to teach climate law because teachers and teachings are important in making sense of, communicating, and even constructing climate law. First, the production of climate law scholarship has indeed supported the improvement in climate law practice. For example, the growing body of research on climate litigation has offered insight to overcome the legal hurdles for climate lawsuit to be successful. Besides influencing legal fields with their scholarship and practice, academics can also teach and mentor students who will shape future development of climate law as scholars and practitioners. My study of the substance and format of available climate law courses, primarily in Canada, has shown that the doctrinal and the theoretical legal knowledge a student may discover in the classroom on the topic concerning international featuring key treaties and relevant negotiations. At the University of Toronto, students learn the roles of customary and treaty-based law, the evolving UN climate regime, the scope of international litigation, and the subfields of international law that have important implications for climate change, such as human rights law and trade law. Aside from applying traditional pedagogies like lectures and discussions, innovative methods have been tested. At McGill, climate law constitutes part of the course of international environmental law and politics. So one of its exercises was group students as different country delegation to simulate international climate negotiation. I put some pictures I took in 2017. So it's a climate conference co-hosted by Fiji and Germany. Look beyond Canada, many schools adopt the same teaching topic as their Canadian counterparts. They also apply similar methods, including in-class lecture, discussion, and climate negotiation simulation. What stands out at Vermont Law School, which is an American law school, is its service learning innovation. So what they do is the instructor guides students to do the on-site work on the annual climate change negotiation and to build a semester-long relationship with partners, mostly the least developed country delegations, to support to do the research and support them in the negotiation process. Now I will come to my conclusion. My research, together with recently published work by other scholars, because these 2 years there are several papers published, may serve as a conversation opener in order to develop a venue for sustained reflection on the objectives, structures, pedagogies, and institutions relating to climate law and climate law teaching and learning. As you may have noticed, I have primarily used climate law courses in Canada for illustrative purpose. The school chosen for my analysis are not representative of all law schools and might not tell the whole story. So meanwhile, I still know very little about students' learning effectiveness in the review courses. So my first step will include have more case studies, maybe include like schools in China and US or UK, and to obtain data to understand students' experience about attending climate law courses. That's all I want to share today. Thank you for listening.
Thank you very much, Ling. A fascinating presentation, sharing your experiences teaching in the area of climate law, but also with tips and innovative ideas that I think apply to a wide range of international law disciplines. And now we turn to another international law discipline, that of international migration law. And I'm very pleased to introduce Vera Honoskova, who is a senior lecturer at the Department of International Law, the Faculty of Law of Charles University. And Vera's presentation is entitled International Migration Law Courses, a Laboratory of Teaching Methods for International Law. And I should just say quickly that we're getting a number of questions in on the Q&A box. That's fantastic. Please also feel free to vote up and down questions, as we're likely to be pushed for time in the Q&A, so we can prioritize those that many of you would like asked first. So without further ado, I'll give the floor to you, Vera. Thank you very much.
Thank you. I'm going to share my PowerPoint presentation. And first of all, okay, I would like to thank you very much for this wonderful initiative and for the possibility for me to talk here. As you said, Jason, I'm working for Faculty of Law of Charles University. I teach migration and refugee law there, but apart from that, I'm also teaching international law. So I can kind of interconnect the methods which I use here and there. I'm going to talk about a set of migration and refugee law courses, which can be seen as a, let's say, laboratory of teaching methods. And they also can be used for teaching international law. I would actually love to start with questions. I would love to ask you, like all of you, all the audience, do you use simulations in your teaching? Do you use moot courts? Does your school have a legal clinic? And if anything like this sounds familiar, I would love to ask you to raise your hand, but that's not possible. So please do it for yourself, raise your hand for yourself. And those of you who have raised your hand, you know what I'm going to talk about probably, and I would be really happy to discuss and share the experience we have together. So what I'm going to talk about the teaching specialization on in refugee and migration law. We have, or this specialization is formed by 14 interlinked courses, which form a teaching specialization together. And it's only one of many teaching specializations here at our faculty. And just to explain, the graduates from the law faculty must study and pass prescribed syllabus consisting of compulsory courses, for example, public international law. And those compulsory courses are from all the main fields of law. And then they have a wide range of optional courses, including those on migration and refugee law. Students can choose to either study an optional course separately or to complete a set of related optional courses that taken together are termed as module. And each module focuses on a specific area of law and enables students to specialize in it. And if a student finishes a certain number of courses in one of the modules, then he can obtain or she can obtain a graduation certificate, which he or she can show to a future employer as a proof of detailed knowledge in the specific area. The teaching specialization I'm going to talk about is consists of courses which apply mix of different learning and teaching methods. The courses can be put into 4 groups according to which methods they use. One is classroom-based learning, another can be named learning by doing, another learning by playing, and then we have also a course which can be named as learning through researching. All the courses reflect the objectives which students should achieve in the learning process across a range of knowledge, skills, values, and attitudes. I think that we can see two types of inspirations for international law. In my opinion, the two inspirations are that first, we can kind of tell you from our point of view, of course, which methods work for which learning outcomes. We can tell you how effective they are or how costly they are, actually. That's one thing. And then another experience or another type of inspiration is our experience with teaching knowledge. I mean, teaching that focuses on knowledge through different methods and not traditional methods. Well, how to, the first type of inspiration, let's say. Let's focus on one of the groups on learning by doing at first. This is a group where courses include real life experience through internships, externships, and legal clinics. Here we focus mainly on skills. I tried to show it here. Although knowledge and values clearly play a role. What we do here, students go on various placements. They are offered placements with law firms, UNHCR, state authorities, and NGOs. Students spend at least 1 day per week on placement throughout the semester, and their work may include, for example, drafting legal documents such as appeals or draft decisions, conducting interviews with clients, researching the law, and suggesting ways in which legal problems can be resolved. In some courses, students even work with real clients, mainly the legal clinics. When we started to build this type of courses, we found out one very important thing, that what is really the key, in our opinion, is the structured reflection. It plays a huge role in the learning process. If students do not receive good structured reflection, the level of acquired knowledge and skills is much, much lower. Another group of, let's say, group of courses can be described as learning by playing. Here we focus on both skills and knowledge. And just to give you an idea, I put some pictures here. The first, or the upper one, is from an EduLARP, Educational Life Action Role Play, where students play roles of refugees, of UN workers, of internally displaced persons. And we do this course in a cooperation with the Czech army. So there are also soldiers who, let's say, act as themselves. We have a written scenario. The scenario is that all players, let's say, or students and soldiers are in a fictitious country where there is a war, and they need to, in case of refugees, of course, to find shelter. In case of UN workers, they need to help refugees and IDPs to conduct interviews, for example. So the students need to learn the knowledge. They need to learn about refugee law and humanitarian law, because they need to know it for their role. So they learn it before they start the game, the course. They also then later during the game, let's say, they learn how to conduct interview, how to negotiate, how to use the knowledge they have. The second picture is from an asylum law moot court, which is a course where students prepare written submissions, and then they act in oral pleading. They act both as state officials and as refugee lawyers. And we have real judges actually giving feedback to them. This particular course is also something which is done together with other faculties, and there are people from, or students from the Czech universities and Slovak universities who learn together, let's say. And again, also here, the role of reflection is really crucial. Students learn much more with structured and detailed reflection than without, of course. Those methods which I mentioned here, we use them as a method for the whole course, but of course, it can be also used just for one seminar in a form of a short activity. For example, small moot court can be played as an activity in one of the seminars, for example, on international human rights law. Is there inspiration for international law? Yes, I think so. I think that I actually named it inspiration number one. And I would describe it as following. When designing courses, we as teachers always look at specific course learning outcomes, as well as on the overall goal of the law faculty. There needs to be constructive alignment across the outcomes and goals, learning activities and assessment regimes to ensure that the student progresses and eventually graduates with the knowledge, skills and values that are necessary for post-university working life. So the putting together the outcomes, goals, learning activities, and assessment regimes is very, very important. And that's something what we also brought from teaching here in this particular courses to our other courses. So if your learning outcomes include skills, values, attitudes, then you can choose to include the above mentioned methods to your courses, for example. If those above mentioned methods are not of that much interest for you, I think we can offer you one more possible inspiration, and it's teaching knowledge through, let's say, less traditional teaching methods. We try to work with this in one of the courses that focuses on knowledge primarily. So it's one from the group classroom-based learning. The overall course goal of the course is to give students a really deep knowledge of refugee law. We used to use lecture-based teaching before. That meant that teachers delivered speeches, let's say, to students who took notes, and then the assessment was done by an oral exam at the end of the course. We have changed this approach later, included interactive activities, changed the way we evaluate, and then decided to change the teaching method, the whole teaching method, to student-centered learning activities. And now we use a method which we later found out as being close to the flipped classroom technique. The result, in our view, is motivated students, motivated teachers, the same level of knowledge as was acquired by students before, but with better understanding. Yeah. The course which we have consists, the course I'm talking about is consists of 11 interactive seminars, and students prepare before the seminars. They watch videos, including a 30-minute video presentation by the teacher. They read academic and newspaper articles, documents, other materials, analyze case law, or prepare various submissions. During the seminar, teacher guides students through the content with the use of different activities or assignments. Students work in pairs, in the group, they solve problems, discuss. We also use a lot of fictional cases. To ensure that students gain the knowledge that we want, we often use quizzes at the beginning of each seminar to find out what students know and what they understand. And then we usually focus on several main topics in each seminar, and all the activities are designed in the way that they deepen students' knowledge of the particular topic. Teachers, of course, provide structured reflection aimed primarily at knowledge, but also on skills. Sometimes the students at the end of each seminar and then, of course, at the end of the course. So I think this is inspiration number 2, which we can see here. In my opinion, the inspiration can be, how to formulate it, this, let's say. We always try to define learning outcomes, which helped us very much. We didn't do it before, but now when we do it, it's just much better. The courses are giving a lot, much more than they used to give to students. So defining learning outcomes, choose adequate learning and assessment activities. What helped us a lot too was to start working with the attention curve. It's not, you can't see it very well, but it's here. It's a way how to think about the time frame of the lecture, about how to deliver what you want to deliver. Because activity or attention of students is sometimes slower, sometimes higher, and you can help them. You can help them by actively working with this attention curve, with changing of activities, as the attention always goes up when you change an activity. So when you know which minute you should concentrate on changing your method, it helps a lot. What also helped us was making a deal with students about how the seminar will look like at the beginning of each of the seminars, of the courses, I'm sorry. And, you know, students are always very surprised when we ask them not only what are your expectations from us, what are your expectations from the course, but we also ask them, what is it that you yourself bring into the seminar? What is it that you are going to give into the seminar so that it goes as you want it, as we want it? And I also think that the flipped classroom method is worth trying. At least it seems to work in the courses I mentioned, but when the structured reflection is included, of course. Thank you for your attention. I'm looking forward to your questions. Thank you.
Thank you very much, Vera. An excellent presentation and some really practical tips there that I think we can all learn from and draw on in our own teaching. So thank you. That's great. We have a really full questions box here. We'll do our best to get through as many of these as possible. I'll try to go to those that have been upvoted, but also have to bear in mind that some are along the same theme, so try and get to those that are representative and also give each panelist a chance to speak. So let's turn first to the question that's been upvoted the most on here by Eric Scarf, who says, and I think this is to Jason Beckett, is this an argument against international law or against all law? It is unclear to me why these problems are unique to international law and wouldn't equally apply to garden variety examples of state-based law. And maybe I could also add to that the next question, in the interest of time, given by Dr. Saunder, who says that Jason Beckett's view is quite a radical point of view. However, there have been positive impacts of international law, human rights law in particular, on domestic laws and policies. I will cite the example of Pakistan in this regard, repealing the draconian Hudud laws that targeted women and enacting women protection law in Pakistan as a byproduct of ratifying CEDAW. There are so many others. Isn't it too extreme to call teaching, studying international law as pointless and useless? Jason, over to you.
Okay, thank you. Two really excellent questions. So yes, first of all, I have a tendency to overstate my position. I like polemic as a mode of engagement. On the first question, yes, absolutely. I hate municipal law almost as much as I hate international law. But I hate them for slightly different reasons. So yes, I fundamentally believe that law is a tool of repression, oppression, and exploitation. That's what it was designed to do, and it's done it very well. But it's also a tool for legitimating repression, oppression, and exploitation. And one of the easiest ways to legitimate these things is to outsource them. It's to send them somewhere else. So during the period of the Industrial Revolution, the European countries exploited their own, well, first of all, created and then exploited their own working classes to degrees that almost led to revolution. And as Cecil Rhodes pointed out, the easiest way to avoid civil war was to export that exploitation into Africa, into Asia, into Latin America, if you could get access via the US. The difference, I think, is that municipal law is in some sense a real thing. We have courts, we have police, we may or may not have legal rules, depending on how you read the sociology of legal judgment and the sociological after effects of legal judgment. The point that I want to make in international law is that on the one hand, you have the system that resembles domestic law. So the system that Dunia calls international economic law. And that is predictable, it is determinate, and it is enforced with brutal consistency. Then you have this other system that we call international law. And that isn't enforced, it isn't determinate, it isn't actually identifiable. So for example, Vera spoke about teaching refugee law as if that was a thing. And I was really struck that I have some colleagues in the Center for Migration and Refugee Studies at AUC who just compiled this wonderful report on the rights of refugees in host countries. And I was really struck by the fact that this whole report was financed by the European Union. And that's the same European Union that are allowing refugees to drown in the sea, that are funding concentration camps in Libya, that are funding border patrols in Morocco and Egypt and Libya. So, and in this, I see this really fundamental disconnect, that we have a regime for treating refugees. We actually have a regime for creating refugees who are ultimately only following their own stolen resources. And then we have this fictional regime for telling us about how we should treat refugees. But the fictional regime has no purchase, it's not going to affect government policy because countries like Egypt don't have policy control. And that would lead me to the second question. And I would say yes, human rights law does occasionally have an impact on the drafting of domestic legislation. But if you look beneath that, those changes have very little effect. So Egypt prohibited female circumcision in 2005 as a result of ratifying CEDAW. The only result of that is that the conditions under which circumcision take place have gotten worse. And when things go wrong, people can't go to the hospitals. So in other words, the practice never changed, but the change in the law made the practice even worse. So to summarize this in a final way, and I wanted to avoid saying this, but I will say it. International law isn't pointless. That was an unfair thing of me to say. The role of international law is to justify or disguise the neo-colonialism of the Euro-American project. So it's not useless, it's part of the problem. I'm going to stop because I always speak too much.
Thank you, Jason, for those thoughts on those questions. Would anybody else like to come in on that or respond to what Jason has said? In that case, then perhaps we have a question here for Vera next from Nadia Corniotti. And Nadia says, from my experience, I have observed that sometimes students might become too real in assuming their roles in learning by playing, often forgetting that this is just a simulation, dealing with very real problems of very real people. As a result, they become too competitive, losing the empathy needed for humanitarian type work and or disconnecting from the reality, focusing on it being a game. I have therefore been reluctant to use such methods, especially for migration, refugee, international humanitarian, human rights, etc. Do you address such concerns in any way? Vera, do you have thoughts on that?
Yes, that's actually a very interesting question because I don't have this kind of experience. We have, maybe I should say that we have three courses that are based on this method of simulation. The moot court, which I put aside. Then we have a simulation of Council of the European Union, which is in classroom, so that's kind of safe from this point of view. But I'm sorry, I forgot the name, Nadia, or was asking about. I think it's only the question. It's a question for only one of the courses, the one which is done together with the Czech army. Maybe what I thought for myself, we don't have such experience, probably because students play only the roles of refugees or UN officials, UNHCR officials, or IDPs, and they do not play roles of the soldiers. I'm not sure. I would think about it much differently if students would also play the roles of the soldiers. Right now, we don't need to think about it because it's kind of safe from this point of view, because the roles they have, students always get a role that is written or well, somehow described on a paper. The role, the description is short. The main thing I think is that they have a goal of each of the roles. And then students try to, for example, get into safety, or there are, for example, roles of women refugees who are delivering child on the second night of the simulation. So then they are searching for better life, let's say, for the child. It's of course a bit more complex than I'm explaining it now. And we never experienced this, like you said, losing empathy or focusing it only on being a game. We never experienced it. But as I said, if the roles were different, then I would think about it, and I would probably, I would think about it. We even now, they of course can any time during the game, they can say, well, we are quitting the game because it's too much, it's too frustrating, too, I don't know what. So still there are some mechanisms, but I think you wrote about something different, which we did not experience now. But it would be nice to talk about it a bit more in details. Thank you. If it's okay.
Thank you, Vera. And I should say also, if any of the other panelists want to jump in, feel free to just unmute yourself and jump in on any of these questions. In the interests of time, and because I want to give all of the panelists a chance to answer questions, I'm now going to move to the question that's directed to Ling Chang. That comes from Arif Hamdani Gunawan. And Arif asks, can all countries, both developed and developing countries, rely on their international climate law interests in the United Nations Framework Convention on Climate Change? This is important because there are different interests of developed countries who want to market products that are sophisticated and have the ability to be environmentally friendly, while developing countries are more concerned with products that are functional and affordable. Ling Chang, would you like to come in on that one?
Thank you so much for this very important questions. For me, I think the UNFCCC still a very fair venue for developed and developed countries to have their voice heard, because there are recently some discussions on climate clubs. It's smaller group of countries. They try to take climate actions or have smaller scale climate cooperation between each other. It's more focused on some powerful countries. So there's countries arguing that. So that's just top climate issues under the UNFCCC. So in the framework itself, there's some framework or rules designed to take into consideration of the different capacities, like the CBDR, the common but differentiate responsibilities, and also the national determined contributions. So to allow countries to have their own domestic climate policies. But specific to your questions on the product, whether have the environmental friendly products or affordable product. I'm not an expert on these questions because it's more involved the intersections between climate law and trade law. It's also a very emerging topic for some very good scholars. So you probably can search for the questions for their research, but thank you so much.
Thank you, Ling. Now, a couple of questions for Dunia, perhaps. The first question from Abdul Malik Al-Tamimi, who asks, when the practice of international economic law is international, why is the coloniality of knowledge a problem here? Coloniality of knowledge should not stop African, Asian people from writing, teaching, about their regional trade agreements. And perhaps also we could jump back up to Andrea Pelliconi's question, and maybe Jason, you might want to come in on this too, if you'd like. Now, Andrea asks, isn't it defining the international poverty line in terms of dollars a day a form of colonialism itself? Pro capita dollars tell nothing on actual purchase value in countries other than dollars users, wealth distribution and disequality, informal pay and wealth, and so on. Shouldn't wealth and poverty be evaluated in terms of resource deprivation, access to services, food, water, and so on? Do you want to give those a go, Dunia, and perhaps others can come in afterwards?
Thank you very much, Jason. I will start with the question by Abdul Malik Al-Tamimi. I hope I'm pronouncing it well. Coloniality of knowledge should not stop African or Asian from writing or teaching. I also agree in principle. In practice, the problem that I've noticed, that I've observed, for example, with my experience in at the University of Namibia, but elsewhere as well, including in South Africa, is that there is one way of framing the question that I've raised about decolonizing international economic law is to look at the financial interventions. If you compare, for example, what African universities in general invest in academic research, including the publication of IEL text, you will see that the amount is negligible. So there is a practical, pragmatic reason why I would say IEL teachers find it difficult to publish because there are a problem of incentive, financial incentives. For example, if you compare very quickly Namibia on the one hand and South Africa on the other hand. In Namibia, there's no financial incentive, at least in the Faculty of Law, financial incentive for publishing an IEL text because the government of the university will not pay the scholar for publishing. Maybe you will get a promotion after a few years, but in South Africa, on the other hand, there is a financial incentive for people to publish. In practice, what it means is that it becomes harder and harder, taking into account that many teachers or many lecturers have very heavy teaching workloads. It becomes very difficult for them to write the text that will be relevant and useful for the students. So it creates a situation where if you go to the library, you're likely to find the textbooks that I've mentioned in my publications. They come from well-established publishers like Oxford University Press, Kluwer, but there's no conspiracy against against academics in Africa. It's just that for very pragmatic reasons, including the financial aspect of it, it's very difficult to actually get out the text that will be relevant to students. I have to say, though, that in recent years, for example, using Namibia, because that's the example that I've been using throughout, that they've been texts that are more relevant to Southern Africa and Africa in general. I'm thinking in particular about the book on regional integration by Professor Opong, and also about regional agreements in Africa by Professor Gatti. But you would see that the problem, or let's say that the problem that I would face as a lecturer is that they are very specific. They are not the kind of textbook that you can use in an introductory course. You need the breadth, you need the scope in order to use that text as a prescribed text for your students. The rule at the University of Namibia was that the content should be 75 to 80% of the content should be relevant to the course. So it would have been practically very difficult, even with those specific textbooks to teach. So in principle, and in the ideal world, I would say, yes, I fully agree. The coloniality of knowledge should not stop any one of us from publishing, but for very pragmatic reasons, including especially financial reasons, it is very hard for at least lecturers in the South to actually get those texts out. South Africa is quite an exception in terms of funding of research. Most universities, unfortunately, on the continent, most universities, unfortunately, do not have those kind of financial incentives, and they don't get the text out. So that is the question asked by Altamimi, and I hope I answered your question. I'm quickly going briefly to the question asked by Andrea Pelliconi, because I know Jason will also chip in. Isn't defining international poverty line in terms of dollars per day a form of colonialism itself? To that question and to the other one, to that question, I would say, a bigger picture answer and then a specific answer, but I will be brief. The bigger picture answer is that your question underlines the importance of including other perspectives when teaching international economic law, including, for example, development studies, because for me, development theories can enlighten the teaching of international economic law. And this is very important because if you use the doctrinal black letter law approach that you find in most textbooks, including the main textbooks or main titles in international economic law that I've spoken about, if you look at those titles, what you realize is that they don't use several approaches apart from the doctrinal one. That would mean that if you were to ask this question in a typical international economic law class, your lecturer will tell you that this is not a legal question because to a great extent up to this day, I believe, many people will say that law is doctrinal. I mean, it is, you have to look at the text. Like Jason said in his presentation, you must be able to read the goddamn, sorry for the expression, you must be able to read the treaty, the goddamn treaty. So if you were to ask this question in a typical law class, they will tell you it's not a legal question. But for me, it is a question that should be asked in international economic law. And that is, now I'm going to look at the specific, this is the specific part of my answer. You say that it's a reflection of colonialism itself. I would say yes, to a great extent, because as a matter of fact, not as a matter of law, as a matter of fact, the US dollar is the world's reserve currency. So this is how the US dollar underwrites the international economic system. There is also in your question, from your question, there is a necessity to also measure poverty in terms of other, I would say, other criteria. And this is the kind of debate that you'll have if you were to include developmental theories or development theories in your class. Because very briefly, I would say that economists, for example, and you mentioned it in your question, economists, for example, they are trying to include power parity purchasing, power, in the sense that they are trying to take into account the purchasing power of people when, for example, measuring the economy, when measuring the level, for example, of poverty. But I get your point, and I fully agree with you that in measuring poverty, we have to include other criteria, including resource deprivation and other type of deprivations. In fact, again, if a lecturer decides deliberately to include development theories in his international economic law class, you'll be able to answer these questions, and even to tell you that the work of the likes of Amartya Sen have, especially his book, Development as Freedom, emphasize those aspects that you have raised in the question. So you say that I know it's naive, but it's not a naive question. It's actually a very important question. It reflects I would say, not the Eurocentrism, but the Americanism of the international economic system. It reflects the doctrinalism problem. It raises the problem of doctrinalism in the sense that it is not regarded by most as a legal question, but it's a question that should be regarded as relevant, directly relevant to international economic law. And it also illustrates the neoliberalism that permeates the international economic law system. In conclusion, there is a need, and that is one of the arguments that I make in my presentation, there's a need for an intervention that is methodological in nature. We need to address those questions, issues of poverty, issues of how to measure poverty, and how it relates to international economic law. Unfortunately, the problem has been that that currently, if you look at the way international economic law is taught, especially in Southern Africa, based on my experience, you don't have that kind of approaches, and it's something that needs to be changed.
Thank you, Dunia. We're out of time, but I'd like to give Jason, Ling, and Vera a chance to come in on that question, but also any other final points they'd like to make. Perhaps if you have something to say in a minute or so, please make your concluding thoughts.
So I would like to make 3 quick points. One, coloniality of knowledge, and I think particularly coloniality of authority. I think the easiest way to realize this is a problem is the fact that this seminar is taking place in English. And probably for most of the participants, it's not first language. Quite likely for most of the audience, it's not first language, but it is the colonial language that we're expected to present our ideas within. So related to that, in response to Andrea, yes, absolutely. Using dollars is a completely colonial way of looking at things. All I wanted to illustrate, though, is that the development project is designed to keep poor people poor, to make them more poor, and to keep rich people rich, and to make them more rich. And I think the fact that if you push its own signifiers, if you push its own techniques of justification and measurement, like purchasing power parity, hard enough, then you see that even in its own terms, this project can no longer self-justify, and yet it's allowed to continue precisely because the coloniality of knowledge means that most people in the developed world don't have to confront what the development project is doing. Two final points. One, simply because James Gatti was brought up. Again, coloniality of authority. One of the reasons that the World Trade Organization is in such a pickle at the moment is that the Obama administration consciously blocked Gatti's appointment to the appellate body of the WTO because they didn't want someone with his politics in that space. And then just a final point for those who want to challenge a little bit the coloniality of knowledge, Yash Tandon's book, Trade as War, is, I think, the best easy text I've read from an African perspective on everything that's wrong with the global economic international law system. And also thank you again to the organizers for organizing, for making this work, and for inviting me.
Thank you, Jason. Vera?
Well, I saw some more question in the questions and answers, but I replied to some of them with a question if we may continue discussing via emails. So I think that I would just thank you all. Thank you all to my colleagues, my co-presenters, and thank you for all the audience. Thank you for the organizers, and that's it. Thank you.
Thank you, Vera. Ling?
Thank you so much. Panelists talk about a lot the usefulness of international law, and I start wondering how about international climate law and whether we need to teach it. But I think we should, because it's enterprise that can direct students' attention to this area and to let lawyers to go into this field to do more. So I think it's very important. And lastly, I want to thank so much for everyone here, and also organizer for organizing this. Thank you so much.
Thank you, Ling, and thank you so much to all of our panelists today. It's been a fascinating discussion, and I think the fact that we've run over by a few minutes is testament to the quality and fruitfulness of the discussion we've started today. So this bodes really, really well for the forthcoming webinar series. So many things to talk about. I'm sorry if we didn't get to your question in the question box today, but there'll be plenty of other fora in which to do that over the coming weeks. So thanks again to the organizers. I'll hand back over to Barry and Jean-Pierre, who might be able to say a word or two about the next webinar. Thank you very much.
Thank you very much, Jason. And let me just take the opportunity to say thank you to you for your chairing and for keeping to time as much as possible. From my end, the only thing is to remind the audience that the next webinar will start in about 40 minutes. So at 1:30 UK time, and that will be discussing the teaching of international law in Asia specifically. So the webinar will remain open, so you can feel free to just switch your mics off, etc., and stay on, and then we'll get started again in about 40 minutes. So thank you very much, and thank you again, Jason, and all the speakers and all the audience for attending.